Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. As you can see, it is sweater blazer season here in New York, which I love. I am, as you can see, in New York. That's the Chrysler Building. It's lovely. I didn't open my window shade. And tomorrow's Halloween, which makes this one of the few days, one of the few times of year when I'm actually happy to be in New York, because New York kills it at Halloween. New York Halloween is super fun. It is the only holiday that is fun in New York. To which you might say, but Vince, what about New Year's Eve? What about the ball dropping? What about Times Square? No, don't go to that. Don't do that. If you go to that, you will merely suffer. That is where people go to suffer. It is horrific. It's a bad way to spend any holiday. Do not do that. The only holiday that's good in New York is Halloween. Case in point, half a decade ago, we had ourselves a bit of a terror attack here in New York. People tried to run some folks over with vans. There was some thought that there was bombs planted in trash cans. The police were everywhere. And I gotta tell you, New Yorkers still showed up to party. We were all very sad about the people who had died. We're really bummed out that there might be bombs around the city. And everybody was a little nervous to go near any of the trash cans. But that didn't stop anyone from going to a party. Because that's what New York was. I don't know if it is anymore. We're going to find out. But that's what New York was back in the day. Oh, people are trying to blow us up? That sucks. What neighborhood was it in? Okay, I'll go somewhere else. That was cool. Give New York credit for that. I don't give New York enough credit sometimes. That was cool. And Halloween in New York, I hope, will continue to be cool. I hope. We'll see. Also, you can give away full-size candy bars in New York, and people just say thank you instead of like feeling weird and awkward, because it's New York. You can just literally, people don't really trick or treat, but there's like Halloween parades, and you can just buy like crates of like full-size Reese's and just hand them out, and the parents are just like, okay, you got something to prove, I guess. Thanks. You know, this is amazing. It's like, I do have something to prove. Please enjoy 2 full-size Reese's so I can feel good about myself. Thank you. What can I say? All right. I'm going too long already. We're already at almost 3 minutes. We have a question here from a duo they've asked questions before. And I'm going to call them the Excellent Duo, EGG Excellent Duo, because they told me that they buy 48 eggs at a time, several times a week. In response to my recent posting about how many eggs my egg-laying chickens on the hobby farm are producing and how I'm swimming in an overabundance of eggs. That's what they told me, and I think that is excellent because I don't have a sense of humor. I don't. One of my many failings. And the Excellent Duo asked us, collectively, the channel, obviously, as follows. I could not find a video that you made about if you sue the employer and lose, will they make you pay the employer's attorney fees if they deem the lawsuit frivolous, even if it was a real discrimination claim? Okay. Great question. Common fear. Love that you asked this. And we're making a video to help allay this fear. I'm going to give the simple answer first for all the people, the TLDR people that too long didn't read, right? We're going to give you the TLDR. In the entirety of my career, all the firms I worked at, all the cases I worked on, all the firms I've owned, the firms I've sold, the firms that I have today, probably a combined more than 10,000 cases that I've touched. And never once, to my knowledge, has a single plaintiff in any of those cases end up paying the defense legal fees. Never once. Could it theoretically have happened? Yes. It is theoretically possible, and the rest of this video is going to be devoted to the nitty-gritty of how, in theory, it could happen. But the simple answer is it never once happened in 10,000 repetitions, 10,000 cases, and it's not a realistic fear if you're behaving well. That simple. So all the people who wanted the simple answer, you can click out now. Maybe give me a like, because you're going to end the video early, so, you know, it helps me with the algo if you bump the like or give a comment, whatever it is. Because I gave you the quick and easy, right? Now, for the rest of you, we're going to engage in a 15-minute debacle of complexities. And you're going to get fears that probably aren't realistic fears from this conversation. Just being realistic here. So, first and foremost, I said that I've never seen a plaintiff. We're getting into the complex theory of it all now. First and foremost, I've said I've never seen a plaintiff pay the defense fees. True, accurate. Now, I have seen a fair number of relatively foolish plaintiff's attorneys end up paying the defense counsel's fees, or pay fines, pay sanctions, whatever it is, because they brought a case that had no merit. Why does this happen? Because there are POS, piece of shit attorneys on the plaintiff side who degrade everyone involved in this industry, which is a very important industry. We're defending people's right to earn a living, free from discrimination and sexual harassment. That is an important thing to be engaged in. But around the feet of the real litigators in this industry, you have bottom feeders who will bring cases and settle them for nuisance value, knowing up front, right? Listen, do we have cases that we settle for 20 grand? Yeah, of course. Sometimes you get in a case and some additional risks pop up, or the client wants 20 grand, whatever it is, things happen, right? But I'll tell you right now, if we're signing a case at this firm, it's because we believe this case has real merit, has real value. We can really help this person, and in so doing, we can make money helping this person, right? This is not a junk case. But there is a business model that can make an attorney relatively wealthy by going out and signing, let's just say 100 junk cases, just cases that don't even state a real cause of action in this field, and then suing 100 employers for 100 separate plaintiffs for these junk claims. And solidly 60 to 80% of those cases are going to settle for, between $10,000 and $20,000, often close to $20,000, because even the junkiest case can cost about $20,000 to defend in this field. That's about the nuisance value, because we're in this complex litigation field. We have federal litigation and specialized counsel, and defense attorneys charge so much. It costs a lot to fight off even the junkiest, worthless, nonsense claim. And those attorneys will run around settling those cases, and they'll settle that 60 to 80% of their 100 cases for, we'll just call it 20 grand. And on those 60 to 80 cases, they're going to make probably about $4,000 an hour in terms of their time investment. It's a hell of an hourly rate if you can get it, right? The rest of the cases that don't settle, they're going to cut. They're just going to dump them. They don't care about those people. They've done a public filing in their name. The case had no merit. They don't care that person's name is out there for the rest of their life. They're just going to dump it and walk away. But sometimes you run into an employer who says, I get that it would be a lot cheaper for me to pay you 20 grand, counselor, but I don't just want this case to go away. I'm pretty angry because I treat my employees great. I'm the rare employer. I do it right. And I'm really angry at you, you POS plaintiff's attorney. And I'm going to go after you. I'm going to litigate the ever-living out of this case. And I'm going to go after you personally for bringing this frivolous claim. And when that happens, in those rare situations, those attorneys, of which I can think of many, will get messed up. And they will get a giant bill, or fines or sanctions, whatever it is, and they will pay through the nose to make right what they did. That happens. So that's the first thing I'll say, is part of the reason why it doesn't happen to plaintiffs is because the plaintiffs aren't really expected to have the same depth of knowledge about the field, right? If you got an attorney telling you, this is definitely a claim, let's go, and then it turns out to not be a claim, is it on you? No. Probably not. It's not like you knew you were being bamboozled, right? It's not your job to know the standards of law in this field. That's not what you do for a living, presumably, if you're trying to hire an employment attorney. So we'll set that aside. That's one thing that does happen occasionally. Not often, but occasionally. And I love to see it happen because often it's because an attorney's doing bad things. Now, the next thing that happens, and this is a curious thing, but this can actually result in a plaintiff paying out of pocket. And this is called different things in different jurisdictions, and the rules around this phenomenon are different in different jurisdictions. So I'm going to describe a very, very general rundown of this phenomenon, and then you're going to have to talk to local counsel to figure out what the law is where you are, if you're curious about this. We'll present a hypothetical situation first. Let's just say there's a hypothetical claim. Plaintiff brought a claim. Claim's probably worth about 100 grand. Plaintiff's got a case of the greedies. Plaintiff's demanding 30 mil. Rare, but it happens, right? Excuse me. And this employer says, hey, I think we did mess up here. I think we did mess up, and we're not looking to get over on you. We would like to pay you 100 cents on the dollar to make this right. We really, truly would. And so we're going to make you an offer of 100 cents on the dollar. We're going to make you an offer of the $100,000 that we believe you might win at trial. But we are in possession of your demand for $30 million, and we have no interest in paying you $30 million because although we think we messed up and we want to pay you exactly 100 cents on the dollar what the law requires us to pay you, we're not interested in paying you 30 mil because you wouldn't have earned that in your entire career with us. That's nonsense. That's crazy talk. And like, quick caveat, is it possible that someone in this field will win $30 million? Sure. Yeah. That's incredibly rare in this field, right? Like, that's not the norm. And you would need some very extreme and extraordinary circumstances for that to be true. So, you know, think of that as a 1 in a million case, right? So the employer makes their offer, and they paper it properly with the court as per the procedural rules of the jurisdiction. And they go ahead and try to make it so if you don't take their offer and you go to trial and you win, but you win that 100,000 or less, they want you held accountable for all the defense fees you ran up by chasing your case of the greedies, right? So they'll file the necessary paperwork, and the court, you know, can confirm, yep, that's in place now. They offer you to 100 cents on the dollar. They want to pay you this amount, and if you go to trial and you win this amount or less, you are going to be on the hook for defense attorney's fees. Now, that plaintiff's attorney is in for a world of hurt, right? Because I'll tell you right now, a plaintiff with the greedies is not the most rational of clients. I can think of people, like I can put actual faces of human beings in my mind when I think of people who should have won 30 mil or more. But it's almost never the people who want to demand 30 mil. Like, if somebody actually has a huge case, generally you have to, like, convince them of how horribly they've been wronged and why you should go for so much, right? Conversely, if you got somebody who has a solid claim, if it's a $100,000 claim, that's not nothing. That's a real claim. That you've been wronged. You've been wronged. Everybody can see it. You should get paid. Under the law, calculating the damages as the law allows, 100,000 is a good number for you. That's often the person who says, I hear you and the law, but I'm disinterested. I'd like 100, or I'd like 30 mil, right? Okay, well, it's remarkable that you disagree with the law, because the law is, in fact, what you're well aware controls the situation. Like, you can say you think the law says something different, but it says what it says on the page. The case law is what it is. The legislature has voted as they voted. The law is. It exists. It is objective. Now, there's subjective readings of the law, but that's probably not what the plaintiff with the greedies is engaging in. They're saying, don't care, want more. And they want more for the sole reason that in their mind, they decided they were going to get more, and that sounded awesome. But sounding awesome is not a basis for calculating damages, right? Like when you sell a used car, you don't say, you know, it'd be awesome if I can get 30 mil for this car. You don't say that because that'd be a stupid thing to say. Because the car's not worth 30 mil. And so too, if your case has no functional way of calculating damages up to 30 mil, asking for 30 mil is a dumb thing to do because it's not worth 30 mil, right? So that plaintiff's attorney's got to go to her or his client with the greedies and say, hey, you know how we keep talking about your case is not worth 30 mil? Plaintiff's like, I don't want to hear it from you. Just do the trial. Okay. I'm glad you're confident. But here's the thing, client. If we do the trial and you only win $100,000 or less, you're going to be on the hook for defense attorney's fees, and that defense attorney bills like a crazy person, and you're probably going to end up paying $300,000, maybe more. So yeah, we can win. I believe we'll win. I think you have a solid, strong case. I think we win it 9 times out of 10 if we go to trial. And apparently so does defense counsel, given this offer, 100 cents on the dollar, right? But pretty much everybody knows you're not going to get 30 mil. The only person who thinks you're going to get 30 mil is you. So the reality is you're staring down a shotgun barrel of $300,000, $380,000 in defense costs if you go forward and you win at or below $100,000. And sometimes that client says, don't care, run the trial. Okay. That is your choice. That is an option that could be selected. It is a decision that could be made. But wouldn't recommend it. And I'm going to go ahead and get that recommendation in writing a couple times, no matter how mad it makes you, because you're probably going to sue me when you get that bill for $380,000, because you're going to be like, my attorney never told me. I sure did, and I did it in writing repeatedly, and I saved it. Because I'm not going down. I'm not going down for this giant heaping of stupidity. Not the guy. Not the guy. Throw my career away because you got the greedies, right? So that's really the risk, that scenario. And like, don't get freaked out about that. Because first off, you're going to have tons of notice, tons of decision-making time, tons of runway to decide what you're doing if something like that happens. And also, more importantly, that is an incredibly rare situation. It can't happen everywhere. And in the jurisdictions where something like that can happen, again, it doesn't happen overnight. It doesn't happen overnight, and you will be informed as part of the process. Hopefully you have counsel. If you have counsel, you will be informed about the risks and rewards and everything around that. Now, if you have counsel and you're not informed, and you make the wrong decision that ends up costing you a great deal, that could be a claim against counsel at that point, right? It's their job to warn you about that kind of thing. And now that I've introduced this lurking fear into everyone's minds, let me just close out by saying this almost never happens. This happens in probably like 0.5% of all cases or less. And it doesn't happen in every jurisdiction. It is popular. It is a tactic employed by a couple of employers. And they're also very odd employers. They're employers who tend to be like, yeah, we want to make this right. We want to pay 100 cents on the dollar. We're sorry. We want to do better. We're not going to pay 30 mil though, because that's dumb. Yeah, you're being stupid. Like we messed up. We want to pay 100 cents on the dollar. You are, though, being an asshole with that 30 mil demand, right? That has no basis in reality, fact, or law. So it's a very special employer who engages in that. It's An employer with a very good relationship with their defense counsel, who does want to do the right thing, generally speaking. So just, I don't want to freak anybody out. I'm not trying to give anybody the fears about proceeding these claims. It's a thing that happens, and it pays to be aware of it. I guess. I mean, realistically, you probably don't have to be aware of it. All right, everybody, like, subscribe, comment down below. It helps me to help more people just like you. Take care.